The streams are both going now. CMAC's not going to start their actual stream until the meeting starts, however. Facebook and YouTube are both live.
Thank you, Gavin.
Okay, CMAC streaming on their channel as well. And Miguel, you have the helm.
Great, thanks, Gavin. Well, I think it's officially 6 o'clock, so we'll get this virtual meeting on some support for our tenants started. Just a really quick, some opening remarks and some, housekeeping rules. Let me cover the housekeeping rules very quickly. First, let me thank Dr. Joaquin Arambula, our Assembly member, and Central California Legal Services for joining us today to make this virtual meeting a possibility for a lot of our residents and communities in the Central Valley. We are broadcasting on Zoom and on CMAC. as well as our 2 Facebook pages. So please join us if you are available, and also submit your questions. You can submit your questions through multiple ways. One is through the chat box feature of Zoom. The other one is through our Facebook pages. Our staff will go ahead and raise those questions to the panelists and try and get you answers this afternoon. As you know, we are in quite a bit of uncharted territory, given the unprecedented pandemic that we've seen in our communities, which have led to a significant amount of insecurity around people's housing conditions. And as a city and as a state, there has been numerous efforts to try and provide some services and supports to our residents who have mortgages and rental agreements to follow through with. So we're going to cover some of those options, as well as ensure that you have answers to potential questions that you may have about your own conditions or where to get some help. As a quick reminder, the City of Fresno is still offering residents, individuals, $1,500 and families up to $3,000 for mortgage assistance and rental assistance. If you are one of those individuals who've been impacted by COVID, as a result, you're behind on your rent or mortgage bill, please feel free to contact Reading and Beyond, the Fresno Center, Centro La Familia, Educational Leadership Foundation, the Chicaro Movement Organization, and the West Fresno Resource Family Center. They all have resources to be able to help you with the rental assistance and mortgage assistance on behalf of the City of Fresno. With that, let me walk you through the agenda for this evening quickly. After we hear from Dr. Joaquin Arambula, we will go to the panel members at Central California Legal Services for a brief presentation, and then we will start taking questions, again, through the chat box or the social media platforms. Please, if you want to participate, raise your hand on Zoom or submit your questions on the social media platforms. With that, I will turn over to our Assembly member, Dr. Joaquin Arambula.
Thank you, Council President Arias. The Tenant, Homeowner, and Small Landlord Relief and Stabilization Act of 2020 is a new law that will help Californians remain in their homes while protecting mom and pop operations who depend on rent to survive. This law was made in agreement with many different stakeholders, including housing advocates, tenants, labor unions, rental associations, banking and financial institutions, the state Senate and Assembly, and was signed into law by the governor. It is made up of a set of temporary measures designed to prevent widespread loss of housing through evictions and foreclosures resulting from the economic impacts of the COVID-19 pandemic. Thanks to this law, Californians who have fallen behind on rent or other payment obligations under their lease due to financial hardship caused by the pandemic are now protected from evictions until January 31st, 2021. It does not, however, relieve tenants of having to pay, but rather delays the recovery of rent by landlords until March of 2021. It is important to note that beginning on September 2nd, landlords are able to proceed with evictions that are resulting from lawful causes other than non-payment of rent. Beginning on October 5th, landlords will be able to proceed with eviction cases if the grounds for eviction is non-payment of rent or other charges. But to do so, landlords must serve a notice to tenants, giving them a 15 business day window to make one of the following choices. 1, pay the demanded amount. 2, vacate the premises. Or 3, return a declaration to the landlord signed under the penalty of perjury, indicating that they are unable to pay the demanded amount because of a COVID-19 related financial hardship. If the tenant chooses to return the signed declaration within 15 business days, then they are protected against eviction. So just how long does that protection last? It depends on when this tenant stopped being able to pay rent. For those of you who were unable to pay rent due between March 1st and August 31st of 2020, you can never be evicted for COVID-19 rental debt. During the period between September 1st, 2020 and January 31st, 2021, tenants can never be evicted for COVID-19 rental debt as long as the tenant pays 25% of the rent and other charges due by February 1st, 2021. Resulting lawsuits against tenants for unpaid rent will be handled by small claims courts. This law also gives renters with COVID-19 rental debt a 1-month grace period before their landlord can take them to small claims court to sue for the debt on March 1st, 2021. This law also establishes protections for small landlords who become delinquent on their mortgage payments and a right to a written explanation for borrowers with mortgages on properties with 1 to 4 residential units when they are denied forbearance. While this is a temporary solution, we are working tirelessly to find a long-term solution. Our ultimate goal is to protect tenants and landlords of the 31st Assembly District alike, keeping our families safe and our businesses afloat. With that, I'd like to turn it now over to CCLS to hear their commentary as well.
Hello, thank you for having us here. I'm going to do a short presentation going over how the new California law and also about the new federal law that came into place. So as I said, there are actually 2 new laws that came into place. There is the one that was recently just discussed with regards to California, and there's also the federal law as well. There we go. And as it was stated, rent is still owed in both of the situations. It is not a situation right now where rent has been, you no longer have to pay it at all ever. What happens is it changes potentially when you owe the rent. Neither protections protect people if they threaten health or safety of other residents. And these laws also work together in some instances. So one of the things we want to stress is the need to contact either a legal aid organization in your jurisdiction or an attorney for assistance to verify which laws work together and how they do. As stated, the Tenant Protections Act also provide protection from eviction if the notice requirements are followed by tenants. Another thing that is of importance is the fact that landlords face an increased fine if they do illegal self-help, which means turning off the lights or turning off electricity to force somebody out. There are also credit protections with regards to the financial distress that a tenant may endure. As was stated, one of the first things that you're going to be looking at if you are a tenant who's not paid rent is that your landlord is going to be attempting to receive monies for rent owed between March 1st and September 1st of this year. Landlords have the right to request a 15-day notice to pay rent or quit. If you receive that, that notice will look different than it did in the past. It will have the usual requirements of your name, the location in which you are staying, how you can, if you decide to make the rental payment, how you can make that payment. The other thing it will tell you is the rights under AB 3088, which is the Tenant Protection Act. Included with that, your landlord is required to provide you a blank declaration of financial hardship. If you receive a blank declaration of financial hardship and you are unable to pay the full amount that is being requested for March 1st through the August 31st rent, then you are to sign, either move out or sign the declaration. Read through the declaration. You're signing under penalty of perjury that the information that you are signing is accurate. You will want to keep a copy of that declaration and any communications that you've had with your landlord. Any money that is not paid is not forgiven or thrown out. It is still money that is owed. So it will become consumer debt. If you've been paying rent and now you're finding that you're having the financial hardship between September 1st and December 31st, each month, your landlord has the right to give you a 15-day notice to pay rent or quit, along with the same notice requirements, the notice of your rights under AB 3088, and a blank declaration. So if you have filled out the blank declaration given to your landlord for September's rent, and you've only been able to pay a portion of it, then know that you are again going to be asked that you're going to be asked again each month for the declaration to be signed. So you're going to, every month that you're unable to, make sure you turn in a declaration. You must pay at least 25% of the rent owed. You do actually have until January 31st to make sure you've complied with that 25% of rent owed, but you'll want to do it as quickly as you can to ensure that you have the records needed to prove that you've made compliance. And again, any money that is not paid does become consumer debt. And as stated before, the money that has not been paid, that is owed, can begin to be requested in small claims court. And that is how the landlord will attempt to receive their money. The federal government also put in a moratorium as well, and that covers almost all rental properties. And it also bans evictions of tenants who have issues with paying rent. There is a difference there in that the declaration that you are going to sign for that looks different and has different requirements. This declaration can only be signed by people if you have an income loss or medical expenses, you make less than $99,000 as an individual, and if you have tried to make access, rental assistance that is available in your area. And as was stated earlier in this presentation, there is rental assistance for residents that you can attempt to receive. And then you also have to agree to be trying to make partial payments based on what you can afford. And you must be able to state under penalty of perjury that if you do not, if you are asked to move, that you will be made homeless or put into a unsafe, crowded residence. And as you can see, there are two situations, two declarations, and as an attorney, we are even understanding that this can be difficult. So we suggest that you contact either Central California Legal Services, if you are in Central California, your local legal aid, or reach out to an attorney or an attorney group for assistance. Thank you.
So with that, I will start taking questions. If anyone has questions on the social media platforms, we want to answer those as well as we possibly can for you.
Let's start off with some of the questions that were previously submitted. Laura, do you have some of those questions?
Yes, I have the questions. So does the CDC order apply to me, or does California, the new California law, the AB 38, does that apply to me?
That's a really good question. The answer could be either, or it could be neither. What we want people to understand is that there are multiple safeguards for tenants that start with sort of a floor of the CDC order. It's sort of the minimum protection that you can get right now anywhere in the US. But it says that if your state law or a local law has more protections in it, you can use that one. And so then you have AB 3088, the tenant protection, that also has that. It has more protections in some ways than the CDC order, and in other ways, not quite as much. Different areas where different people will be protected depending on their circumstances. But it says the same thing. It says if there are other provisions in the law that are more protective of the tenant, then the tenant can use those. And so depending on your individual circumstances, depending on how long you owe rent for, how long it's been since you were able to pay, there's a notice requirement in the CARES Act that still may apply to you. The Tenant Protection Act will still apply to you. And if you're in the Fresno City limits, there's also a Fresno City ordinance about evictions that will also apply to you about when rent can be collected. And so what we do when you call us at Central California Legal Services is we get all of that information from you about your circumstances, the property, where it is, and how it's mortgaged, if it's mortgaged, who your landlord is, all sorts of information about what has happened to you since the public health emergency started. And we start to figure out what we can build for you that's the best defense based on all of those things that apply to you.
Thank you for that. Let's go to the next question that I have here from the chat room. Where can a tenant pick up a form in case it is not given to them by their landlord?
So AB 3088 requires that your landlord give you that declaration when they give you notice. And so if they have not given you that declaration and you've gotten a notice, that's a good time for you to immediately call us because your landlord's not following the law. They have to give it to you. They have to serve it with the notice so that you can return it to them within 15 days. And it's the same 15 days that they have to give you notice to move out. So anything that delays you in being able to get that declaration to them, like them not giving it to you on time, violates the law and it doesn't protect you as much as you're entitled to. So there are places that you can get a copy of that. You can get one from us. You can get it from the Judicial Council is about to put out an answer form that will have that. And there are a lot of samples floating around. But what we actually would like you to do is let us know, I got a notice and I didn't get a declaration so that we can help you make sure your landlord follows the law and what they're obligated to do.
Thank you. The following question is, what safeguards are there for any abuse, and who is required to demonstrate that the declaration is true?
Okay, so 2 questions there, and I'm going to take them in opposite order. AB 3088 says that if you are below 130% of the median income of the area you're in, that you don't have to provide proof of that declaration that you have a COVID hardship. Your statement that you sign under penalty of perjury that you have a COVID hardship is sufficient. If you are above that 130%, your landlord will tell you, I think you have a high income and therefore you're going to have to prove to me that you have a COVID hardship. And in that case, you would have to present some documentation. You can start by presenting it to the landlord with your declaration, or you should also hold on to that and be ready to show it to a court to show, I really do have a COVID related hardship. I have documentation that my hours have been reduced and I have less pay. Or I have documentation that my job was discontinued because of COVID. Or I have documentation that some of my family members have had COVID and I've had to take time off work to care for them, or I have extraordinary medical expenses because of that. So those are the kinds of things you're going to collect. And first you'll give it to your landlord, a copy, not your originals, and say, here's my proof that I have a COVID hardship. And then you'll hold on to that in case you have to show it to a court later if your landlord continues to pursue eviction. The second part of that, and I apologize, I just got distracted because I saw another question pop up. For some reason now I'm able to see them.
The question is, what safeguards are there to ensure that there isn't any abuse of the declarations that tenants provide landlords?
AB 3088 increases penalties to landlords for, as my colleague Nikki Love pointed out, what we call self-help evictions, an illegal lockout, or turning off the utilities, or any other means they might have to try to get you out of your home without going through the legal eviction process. And it also has penalties for what we would call a retaliation. And what that means is that your landlord can't evict you because of rent, because you fall under these protections. So they try to evict you for some other reason, but it's not the real reason. The real reason is they wish you were paying your rent. And so there are increased penalties for that as well. And then there are also increased penalties under the CDC order for landlords who aren't following the law. And so while our job generally is we protect tenants, we work with tenants, we ask for you to call us. I will, while we're in a very public forum, put out a caution that if you are a small landlord without legal representation, you need to be talking to the Fresno County Lawyer Referral Service and getting representation before you take these actions, because they are subject to penalty if you're not following the law.
Great. What's the name of your organization again? And what is the best number for anybody who needs help to contact?
Yes, thank you. Central California Legal Services. We are in Fresno. We have a Visalia office. We have a Merced office. And so we are helping as many people as we can, as quickly as we can. The best number to reach us, to give us all of that information, is 800-675-8001. I'm going to say that one more time before I go to the next thing, just to make sure anybody who wants it got a chance. It's 800-675-8001.
Great, thank you. Laura, can we go to the next question?
Yes, so some people have heard that in California, the California law only works for rent if they've missed since March. Does that mean there's nothing they can do if they miss rent before March, so before COVID-19 hit?
Not necessarily. I can't give specific legal advice to anyone's situation because, like I said before, we have to collect a lot of information to know what's going to be the best defense for any individual tenant. But because that CDC order is also in place, and because the notice requirement of the CARES Act still applies to rent that was owed before July, and because we have the Tenant Protection Act, and because there's an ordinance in Fresno, even if you're not protected during that covered period in AB 3088, we still may be able to help you either be able to stay in your home longer than you would be able to otherwise, or find an actual defense that allows you to have the eviction dismissed. And it's also really important to remember that non-payment evictions can't start at all until October 5th. So you at least have a few more weeks that you wouldn't have without that protection.
Great.
The next question is, my lease is month to month. Does this mean that none of the laws are going to do anything to protect me if my landlord decides to just end my lease? How am I going to be protected if I'm month to month?
That's a really hard one to answer. The answer is that there are attorneys all over the country right now who are interpreting that CDC order and arguing to courts all over the country that because the purpose of the CDC order is that no one be put out of their home right now, that if you're a covered person with that declaration, it doesn't matter if it's the end of your lease or because it's a month-to-month lease, your landlord can't put you out of your home. And that's something where I said earlier that there are a few protections in the CDC order that might end up being stronger. That's one of them, because the CDC order has a very, very broad definition of what it means to evict, and it's putting someone out in whatever way you do that. If you have the power to make someone leave their home and you do that, that falls under the CDC order's definition of an eviction. And what that means is that where you wouldn't necessarily have a protection because your lease is month to month or it's ended during the covered period, we can argue at least, and people are arguing, that this applies to you and you still can't be put out right now. How long that will last and what will happen where people are challenging that all over the country, we don't know yet. But we would like you to call us and let us try it.
Thank you. Next question, Laura.
Okay, and then what happens to the other 75% of the rent if I can't pay it between September and January? So is that rent forgiven, or what's going to happen?
So between September and January, and there are two covered periods in the AB 3088 in the Tenant Protection Act. One is from March 1st to August 31st, and that's what we're calling the covered period. And then September 1st to December 31st, that's the transitional period. And I think what we mean by transitional period there, what the law is speculating will happen, is that we're all starting to get back on our feet a little bit. And we hope that it's a transition back to something more normal. During the time between September 1st and December 31st, like you heard a few minutes ago, you have to at least pay 25% of the rent to avoid eviction. It doesn't mean you have to pay 25% of your rent in September and October and November. It means you have to pay 25% of those months' rent and pay all of it no later than January 31st. And that might be a little bit easier for some people who maybe they get employment again in September or October. So they're more likely to have that, disposable income or usable income. Disposable is the wrong word. Usable income by the end of January than they are at the beginning of September. And that's okay. And the law actually asks you to pay at least 25%. You do want to pay what you can pay if it's more than 25%, because it's not forgiven. Okay, the debt doesn't go away. You still owe every penny to your landlord. They just can't evict you for it. What they can do starting March 1st is go to small claims court and try to get a judgment saying you owe them that and collect it from you. So it doesn't go away. It's not paused forever. This is, as I said, the transitional period that's meant for everyone to start being able to get back on their feet.
Thank you.
And the next question is, so this is from a landlord. They wanted to know, they have a troublesome tenant. The tenant has been known to sell drugs, but right now because of COVID-19, they understand that they can't evict that person. So they want to know, what can they do to get that person out?
So again, I can't give legal advice on a situation that I only know a little bit about. So I'm going to give you some general information. And that is that the Tenant Protection Act doesn't keep people from being evicted for just cause reasons. Okay, if they're a threat to the safety or health of other residents, then there are still ways to evict them. But the best thing I can tell you is before you do that, because of those penalties, if you step wrong, the best thing for you to do is call the Fresno County Attorney Referral Service and find someone who can represent you and advise you for how best to do that.
Thank you. So just to confirm that question, you're still allowed to remove individuals who are a safety threat to others.
There is still a process for doing that, but it's not the same process as it's always been. There are still additional notice requirements and other requirements. So in theory, yes, whether you can in your particular situation will just depend on the legal advice that someone gives you when they've heard all of the facts in your situation.
So in other words, there's still a process to allow that to go forward.
There is a process, yes.
Thank you. Next question.
Yes, the next question is, so my landlord's upset with me. I'm not able to pay the rent. I haven't been able to pay it for the last 2 months. But since he can't evict me for that, he wants to do other things, like tell the court that I have a dog in my house that wasn't authorized. Can he do that?
So that's what we were talking about a few minutes ago, called a retaliation. And we do expect some landlords might try to do that they might say, I want to evict you not for not paying the rent, for this other reason, when their real reason is that you're not paying the rent, but they know they can't do anything about that. The question is always going to be, can you prove that that's what's happening? It's what we call a pretextual eviction, and that just means it's not the real reason. But we have to be able to show a court that it's not the real reason. So in situations where the landlord has spoken to a tenant a lot of times, and they're always talking about the rent is late, the rent is late, the rent is late, and they've never mentioned this other problem, okay, then that might be evidence we could show a court that, no, the real reason they want to evict you is about the rent. If they have given you written documents that say your rent is late, your rent is late, your rent is late, and they have, if you're very lucky, maybe they've given you a document that says that dog's fine, we don't have a problem with the dog, then maybe we can use that as evidence. So the important thing there is, no, the landlord can't evict you based on non-payment of rent by just saying it's not that reason, but we have to be able to prove that's what's happening, which can be difficult. So if you think that's happening, what you would want to do is keep really good records, every conversation, everything the landlord says or does, any written documentation, any previous notices they've given you, even if it was a notice that they took back or rescinded and said, never mind, you can stay, whatever it said might be useful. So keep really good records if you think that might be what's happening. And again, call us and we'll help you walk through it and figure out what we can do about it.
Another question, can a landlord choose to sell the house if you're not paying the rent and force you to move out?
So that's a really good question that we're waiting to see how the courts interpret. We would argue that no, right now they can't. That AB 3088, because it applies the protections of the Tenant Protection Act to all renters, all tenants, and also because it says you have to have a reason, and a stated reason, and it has to be a reason that falls under that just cause requirement. We would argue to a court that right now, no, they can't do that. I don't know how long that will be true, and I don't know if that argument will succeed, but again, we'd really like you to call us and let us try for you.
Okay. The next question is, are landlords required to give the declaration in Spanish or in any other language that the tenant speaks?
The AB 3088, the requirement for the declaration says that they have to provide it in the same language in which the tenant signed the lease. So if you are a Spanish speaker only or a Hmong speaker only, and you had your lease in that format, then they have to give that to you in that format as well. What we're going to do about that, if you get the declaration in another language, we don't know exactly yet. We can always provide you with that. We have access to a network that is translating these declarations into many languages right now so that everyone has access. So the question really is, what will you do if they don't? And that's where I want you, again, call us and we will try to provide it for you in the language that you need it to be in. And of course, we also have translation services available to us, as well as a number of people in our office who speak many languages.
Thank you. The next question, Laura.
Does CCLS provide consultations free of charge?
Oh, absolutely. Everything we do is free of charge. There is no charge for CCLS services ever.
Okay, and then I have a question from a landlord too. They mentioned that they're unable to pay their mortgage. How are they going to pay for that with this eviction moratorium?
I don't have a good answer for that, and I will. I know there are mortgage relief programs, and I know there is some mortgage assistance available. That is definitely not my area of expertise. If I may throw that back to Council President Arias, I know you mentioned earlier some relief available.
Yeah, at this point, the relief that we have as a city is for renters and for folks who have mortgages. So it's not, if you own a mortgage, if you live in a house with a mortgage, you can apply for a program and get up to $3,000, but it's not for landlords and their rental properties. It's for your it's for your primary residence. whether it's a rental or a homeowner occupied.
Okay. The next question is, so what if COVID, what if it keeps going up until January? Is the federal government or state government going to do something to keep protecting tenants from eviction?
I can take that one. We are expecting another series of legislation and maybe a relief package when Congress resumes session in the next week or so. We are hopeful that they will take another version of the CARES Act into consideration and have something approved before they complete the session of the year, which I think finishes in October. So that is what we're all hopeful, but there are of course no guaranteed given that it's an election year and the year is almost over.
I would just add on the state side that we're currently out of session, but we start session beginning of January, and that will give us at least the start of the year to attempt to push further legislation that may be able to address the issues that have not been addressed thus far.
And what I can say on behalf of CCLS is that we do expect that the law is going to keep evolving. Decisions that judges make based on what's already out there, plus the action that both the state legislature and Congress take to provide more relief. What I can say is that we will be watching it very, very closely, figuring out how it builds on what already exists, how it replaces what already exists, and whether it's now under AB 3088 or in 6 months under whatever exists then, we will still be there and ready to craft the best defense for you we can out of what's available, whatever it looks like at the moment.
Thank you. Any additional questions, Laura?
Yeah, so there's some kind of declaration that we have to sign. Where do we get it? Who do I give it to? How do I find out how to fill it out, etc.?
So the declaration that's referenced in AB 3088 has to be provided to the tenant by the landlord anytime they give notice, whether it's notice to pay or quit, notice to quit, notice to cure or quit. And quit just means leave, get out. Anytime that the landlord gives notice, they have to also provide that AB 3088 declaration. And what you do is you look at it and see if it's true for you. It has a list of requirements, like I have a COVID related financial hardship, and that can be a lot of different things. It can be job loss, medical expenses, extra childcare expenses, reduced hours at your job. You didn't lose it, you just can't work as many hours because your kids aren't in school. It can be a lot of different things, but you read it, and if it's true for you and you fall in that under 130% of the median income for your area, then you sign it and give it back to your landlord. You want to keep a copy because you want to have proof later that you signed that and gave it back to your landlord. If you have the ability to email it to your landlord, you know you'll have a copy when you need it. The CDC order also has a declaration, and it doesn't have the same time limit. So for the AB 3088, if you get that declaration from your landlord, you only have 15 days to give it back to them. And really, you don't even want to wait until the 15th day. You want to get it back to them as quickly as you can. But the CDC order has a declaration, and it has stricter requirements. And again, you have to sign it under penalty of perjury to be a covered person. But it doesn't have that 15 days from notice. You can give that to your landlord at any point you want to. It's up to everyone's individual judgment whether there's any reason to do it before you have a notice from your landlord. But certainly once you have a notice from your landlord, you would want to give them that as soon as you can. Where can you get those? That's an excellent question. Like I said, it should be provided to you by your landlord, the AB 3088 declaration. The CDC order declaration doesn't have to be. You can get it from us. You can Google it if you have that access, CDC order declaration, and it'll come up very easy. If you don't have that access, though, we're here, and we have it in many different languages, a whole network translating it. I think I saw today it's being translated into Somali and, I don't remember, maybe Korean was the other one that I saw today in our email. So we have access to that for you as well.
The next question is it 15 working days, business days, or 15 days in general?
That's a really good question. It is 15 court days. And court days mean not weekends and not holidays. So, for instance, over this last Labor Day, you had the weekend, but you also had Monday, which was a court holiday for Labor Day. So that would have given you some extra time. So if you get it at exactly the right time, it gives you, potentially almost 3.5 weeks to get it in. But you want to be very careful. So 15 court days, which almost always is the same as 15 business days.
Thank you. Any other questions, Laura?
Yeah. So with CCLS, do you guys have any other? Do you guys have other languages or people who speak like Punjabi or Hmong?
We do have people in our office who speak Hmong. We have people in our office, lots of people in our office who speak Spanish. We have people in Punjabi. Yes, I think we do have. Yes, Nikki's not nodding. Yes, I think we do have someone who speaks Punjabi. I know we have Cambodian. And I'm just thinking off the top of my head, but the other thing that we have aside from people in our office is we do use a translation service for any language where someone comes in and we don't have access to that immediately. So we have many languages and we can work with just about any language.
Great. Next question, Laura. Any others?
Okay, no, that's it.
All
We
right.
answered all the questions on social media and
It looks like we are officially done with questions from the public. So we'll
we
just
got
go.
one more.
Oh, one more. I spoke too soon.
What happens if the tenants are undocumented and the landlord knows? Can they intimidate them?
Oh, so there are a bunch of questions sort of wrapped up in that one. But the short answer is no. The basis for an eviction is, what we've gone over in detail, and it has nothing to do with documented status. And harassing a tenant for any reason is not okay. So that's the short answer, no. It sounds like a complicated situation potentially. And so again, I would say that might be worth seeking some legal counsel for.
So
That's
to
one
be
more.
clear, the eviction protection moratorium protects everyone irrespective of documented status.
Absolutely.
Great, thank you. All right, we'll close up the question
one more.
section.
Sorry, one more. So
Okay.
they're mentioning that the landlord isn't providing any receipts or anything to prove that they're paying. So they're worried that when it comes time, if the landlord were to tell them that, hey, you haven't paid the last 2 months, that they have no proof, is it illegal for them to not provide them any receipts? What can they do?
You can demand a receipt, yes. And also, just as general advice, I would say make sure that you do that when you pay. I know that there are different ways sometimes that we have to pay. Maybe it's a money order, maybe it's cash, but if you can, take in a piece of paper with it that says, I want you to sign right here that I gave you $400 or $800 or however many dollars you gave them. Because you need to have that record for your own protection. Your landlord's job is not to protect you, unfortunately. So you need to protect yourself, and that's the best way to do it, is make sure you're documenting when you pay. If this is something that's happened in the past where you know that you don't have a receipt, try to get one. I would like to remind you, landlord, that I paid $600 in rent last month, and I would like you to sign this document that says so. But if you can't get that, then get what you can get. Did you withdraw it from a bank account? So that you have something that says on the day the rent was due, you withdrew the $600. Okay, that's some evidence that that's what you did with it. Did you fill out a money order and you have the carbon copy of it? Was someone with you when you paid it? So that, they can accompany you if you have to prove that you paid it. And if all else fails, just write down wherever you can, document for yourself. I paid $600 in rent on September 1st, and make sure that you have that and you keep track of it.
All right, perfect.
That's it.
Well, that officially concludes our question and answer section of today's town hall forum on the housing protections and the eviction moratorium. I'm going to turn over to panelists for some final words, and then we'll conclude with Assembly Member Dr. Joaquin Arambula. So Brandy and Nikki, you have the floor.
I will go first and then throw it to Nikki. I want to make sure that the overriding message of everything we want you to remember tonight that we've said is, if in doubt, please call us. We would really like to help. We want to help as many people as we possibly can. We know this is a crisis coming and that there is going to be a lot of volume and that people are going to have a hard time understanding these protections and who they apply to and how they apply and how they work together. And that's why we're here. So please, please, please call us and let us try to help the best that we can. And beyond that, just thank you very much for having us.
Thank you. Nikki, you have the floor.
I'd also like to say thank you for having us. And we want you to understand that even us as attorneys are having to go through and have hours of conversations with each other to figure out and parse out what's going on. And if you're thinking that you're confused, there are people to call. We're here for you. And so give us a call. If you're in another area, not in Central Valley, call your local legal aid or any attorney service so that you can get information no matter what side you are on, whether you're a tenant or you're a landlord. Call somebody, there's assistance out there. Thank you.
Thank you, Nikki. Dr. Joaquin Arambula.
Thank you, Council President Arias. Just wanted to thank CCLS for joining us here today, both Brandy and Nikki. I'm a big fan of CCLS ever since the days that my mom used to work there, and know that they do a lot of good work for our community and know that they will stand up for you as well. And so would just encourage community to make sure that you're reaching out to legal representation during this time if you are struggling and facing potentially eviction. With that, just wanted to appreciate Council President Arias for teaming up with me here on this town hall and allowing us to share this information with our community. Thank you, President Arias. And now with that, your final words, please.
Thank you. Well, it's been an extremely long day today with a full day of 10 hours of a council meeting, but this work is far too important to not also include it in today's task. I just want to thank everyone, CCLS, Central California Legal Services, our interpreters for joining us this evening. I know it takes away time from dinner time, in addition to all the other work that we have to do in burning the midnight oil, but it is extremely important. We have tried to do as much as we can with providing direct financial relief to our residents in the city, but we know that they always have a lot more questions than we can answer. So thank you for being a resource. Again, to our public, contact Central California Legal Services at 1-800-675-8001. Again, 1-800-675-8001. If you have any questions, please pick up the phone. They speak multiple languages. They're completely the right organization, and they're most importantly free for those who need the help. So they're a great asset, and we have them in Fresno and across the Central Valley. So please take advantage of them and make sure that you do all you can to stay in your home. And if we can be of any assistance, please reach out to us too in our council offices at 621-8000. With that, thank you all and have a good evening. And I hope you guys catch dinner now.